Number 5 in the top 10 issues in Florida probate, and this is the right of the surviving spouse to the homestead property. Now, here in the state of Florida, we have all kinds of really specific and technical rights that deal with the homestead. As lawyers, we spend our entire career learning about homestead rights and laws in the state of Florida. There are rights in bankruptcy court, there are rights in tax court, rights in civil court, but specific to homestead and probate, the reason why homestead is so important is we've decided as a matter of public policy that we got to make sure that when someone dies, spouse dies, the homestead is protected for the spouse that's left behind. A lot of this has to do with early in state's history, where husband, wife, whatever would leave a widow behind destitute, leave kids behind destitute. So one of the things that we said here in the state of Florida, going back decades, hell, maybe 100 years, is we're going to make sure that the rights of a spouse, and particularly kids, are protected. And so when someone dies, it is critically important that spouses think about what their rights are. Black and white, right of a spouse to stay in the house after the other one dies. Now, there's a little wrinkle on there with foreclosures and mortgages. They can't avoid a mortgage. But when they are living in a house, they have a right to make that homestead claim. Now, determining how you want to exercise that right is really important. Calculations are pretty complicated because the right to live in the house is not a free ride. There are certain obligations you have as a surviving spouse: make tax payments, insurance payments, take care of the house. And if you're looking at a house that's really valuable, those things can add up quickly. So even if the surviving spouse has a good elective share of the deceased spouse's income or assets, looking at how much it's going to cost to live in that house is really difficult and complicated. So you may elect to take the second side of the spousal rights with regard to homestead, and that is converting it to a tenants in common situation with the other heirs. Sometimes that involves selling the homestead. And sometimes when a surviving spouse looks at the expenses involved, they look at that and go, hey, I don't want to live here. I don't want to pay all these things. So it's right to put a sign in the yard and sell that house. But particularly when we're dealing with contested situations with stepkids or whatever else, that can get complicated. That too is when you get an attorney involved. So you make sure all of the rights are protected. And we didn't even touch on the issue of the rights of minor children in homestead situations, but they kind of go hand in hand with the homestead rights of a surviving spouse. This is obviously complicated, difficult. You need experienced probate practitioner and estate planning to make sure that your rights are respected.